and welcome back, teacher lawyers. Let us review amendments and revisions with cases and bar question and answers. Let's start. So, who may propose amendments to or revision of the Constitution? Section 1 of Article 17 of the 1987 Constitution states that any amendment to or revision of this Constitution may be proposed by 1. The Congress upon a vote of 3/4 of all its members, or 2. A constitutional convention. Amendments to the Constitution may likewise be directly proposed by the people through initiative upon a petition of at least 12% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters therein, as provided for under Section 2 of Article 17. The Congress may, by vote of 2/3 of all its members, call a constitutional convention, or, by a majority of all its members, submit to the electorate the question of calling such a convention. As elucidated in Nambino v. Comelec, a 2006 case, Article 17 of the Constitution speaks of 3 modes of amending the Constitution. The first mode is through Congress upon 3/4 vote of all its members. The second mode is through a constitutional convention. The third mode is through a people's initiative. A people's initiative to change the Constitution applies only to an amendment of the Constitution and not to its revision. In contrast, Congress or a constitutional convention can propose both amendments and revision to the Constitution. In this jurisdiction, there can be no dispute that a people's initiative can only propose amendments to the Constitution, since the Constitution itself limits initiatives to amendments. There can be no deviation from the constitutionally prescribed modes of revising the Constitution. Let us distinguish amendment versus revision. Revision broadly implies a change that alters a basic principle in the Constitution, like altering the principle of separation of powers or the system of checks and balances. There is also revision if the change alters the substantial entirety of the Constitution, as when the changes affect substantial provisions of the Constitution. Amendment, on the other hand, broadly refers to a change that adds, reduces, or deletes without altering the basic principles involved. Revision generally affects several provisions of the Constitution, while amendment generally affects only the specific provision being amended. No amendment under this section shall be authorized within 5 years following the ratification of the Constitution, nor oftener than once every 5 years thereafter. The Congress shall provide for the implementation of the exercise of this right. The Constitutional Convention discussed in the case of Imbong versus Ferrer. The authority to call a constitutional convention is vested by the 1987 Constitution solely and exclusively in Congress acting as a constituent assembly. Instead of directly proposing the amendments, Congress has chosen to call a constitutional convention, which shall have the task of fashioning a document that shall embody the aspirations and ideals of the people. Because what is to be amended is the fundamental law of the land, it is indispensable that the Constitutional Convention be composed of delegates truly representative of the people's will. In order to be valid, the amendments or revision shall be ratified in accordance with the Constitution. Section 4 of Article 17 provides, any amendment to or revision of this Constitution under Section 1 shall be valid when ratified by a majority of the votes cast in a plebiscite, which shall be held not earlier than 60 days nor later than 90 days after the approval of such amendment or revision. Any amendment under Section 2 hereof shall be valid when ratified by a majority of the votes cast in a plebiscite, which shall be held not earlier than 60 days, nor later than 90 days after the certification by the Commission on Elections of the sufficiency of the petition. In Tolentino versus Comelec, the court held that there is, and it is the condition and limitation, that all the amendments to be proposed by the same convention must be submitted to the people in a single election or plebiscite. The language of the constitutional provision is sufficiently clear. It says distinctly that either Congress, sitting as a constituent assembly, or a convention called for the purpose, may propose amendments to this Constitution, thus placing no limit as to the number of amendments that the Congress or the convention may propose. The same also definitely provides that such amendments shall be valid as part of this Constitution when approved by a majority of the votes cast at an election at which the amendments are submitted to the people for their ratification, thus leaving no room for doubt as to how many elections or plebiscites may be held to ratify any amendment or amendments proposed by the same constituent assembly of Congress or convention, and the provision unequivocally says an election, which means only one. At this juncture, let us distinguish the quantitative test and the qualitative test. The quantitative test asks whether the proposed change is so extensive in its provisions as to change directly the substantial entirety of the Constitution by the deletion or alteration of numerous existing provisions. The court examines only the number of provisions affected and does not consider the degree of change. The qualitative test inquires into the quantitative effects of the proposed change in the Constitution. The main inquiry is whether the change will accomplish such far-reaching changes in the nature of our basic governmental plan as to amount to a revision. Whether there is an alteration in the structure of the government is a proper subject of inquiry. Thus, a change in the nature of the basic governmental plan includes change in its fundamental framework or the fundamental powers of its branches. A change in the nature of the basic governmental plan also includes changes that jeopardize the traditional form of government and the system of checks and balances. Before we go to the bar question and answers, let us review the ways of proposing amendments or revision. First, Congress may directly propose amendments or revision by 3/4 vote of all its members. In such a case, Congress will not be acting as a legislative body but rather as a constituent assembly, a non-legislative function of Congress. Second, through a constitutional convention. A constitutional convention is a body separate and distinct from that of the Congress itself, whose members shall be elected by the people of their respective districts. Third, through people's initiative. People's initiative on the Constitution is done through a petition, but the petition will have to be signed by at least 12% of the total number of registered voters, provided that in each legislative district, at least 3% of the registered voters therein shall sign the petition. 2017 bar exam question. A priority thrust of the administration is the change of the form of government from unitary to federal. The change can be effected only through the constitutional amendment or revision. Question. What are the methods of amending the Constitution? Explain briefly each method. Suggested answer by the UP Law Center. The Constitution may be amended or revised by the vote of at least 3/4 of all the members of Congress acting as Constituent Assembly by way of a proposal. Any amendment or revision under this provision shall be valid upon ratification by a majority of the votes cast in a plebiscite, which shall be held not earlier than 60 days or later than 90 days after the approval of the amendment or revision. The Constitution may also be amended or revised by a constitutional convention. Congress may, by the vote of at least 2/3 of all its members, call a constitutional convention, or by a majority vote of all its members, subject to the electorate, the calling of a constitutional convention. Any amendment or revision under this provision shall be valid in the same manner as in Article 17, Section 1 of the 1987 Constitution. Amendments to the Constitution may be directly proposed by the people through initiative upon petition of at least 12% of the registered voters and at least 3% of the registered voters in every legislative district must be represented. The people cannot propose revisions and may propose only amendments. The petition must be signed by the required number of people, and the full text of the proposed amendments must be embodied in the petition. Any amendment under Article 17, Section 2 of the 1987 Constitution shall be valid when ratified by a majority of the votes cast in a plebiscite, which shall be held not earlier than 60 days, nor later than 90 days after the certification by the Commission on Elections of the sufficiency of the petition. Question letter B. Cite at least 3 provisions of the Constitution that need to be amended or revised to effect the change from unitary to federal, and briefly explain why. Suggested answer by the UP Law Center. Examples of provisions that need to be amended or revised to effect the unitary to federal. 1. Article 10, Section 3 must be omitted because the legislature will no longer define the scope of the powers of the government. Article 10, Section 4 will have to be omitted. The President will no longer have the power of supervision over all local governments. And 3. Article 10, Section 5 must be omitted. Congress will no longer be allowed to impose limitations on the power of taxation of local governments. 2019 Bar Exam question. A proposal to change a provision of the 1987 Constitution has been put forth as follows. Original text. The Philippines is a democratic and republican state. Sovereignty resides in the people, and all government authority emanates from them. Proposed text. The Philippines is a democratic and socialist state. Sovereignty resides in the party, and all government authority emanates from it. Question. Is this an amendment or a revision? Explain. Suggested answer by Attorney Enan Flores. This is a revision. Using the qualitative test, the proposal will accomplish such far-reaching changes in the nature of our basic governmental plan as to amount to a revision. A change in the nature of the basic governmental plan also includes changes that jeopardize the traditional form of government and the system of checks and balances. Question. Briefly explain the process to revise the 1987 Constitution. Suggested answer. There are 2 basic steps in this process. 1. Proposal. A revision of the Constitution may be proposed by A. the Congress upon a vote of 3/4 of all its members, or B. a constitutional convention. The Congress may, by a vote of 2/3 of all its members, call a constitutional convention, or by a majority of vote of all its members, submit to the electorate the question of calling for such a convention. And ratification. The revision shall be valid when ratified by a majority of the votes cast in a plebiscite, which shall be held not earlier than 60 days, nor later than 90 days after the approval of such amendment or revision. And we're done. Thank you so much for watching, and I wish you all the best in your studies. You can do it.